Welcome everyone. My name is Andrew. I'm the founder and owner of IBIS Prep, and today we are going to do a Florida multiple choice workshop where we go over the IBIS questions for civil procedure, criminal procedure, and evidence. And I'm super excited to do that. Just a few things that I wanted to share with the class before. Can everyone see my screen? Okay, perfect. This is the boot camp. It starts the um February 10th to 21st, right? It's our fourth boot camp, and we've had outstanding results. It meets from 10:30 to 2:30 on Zoom like this, or uh live. The live seats are really filling up fast. I feel like there's not that many live. You can see it's not a huge table. This is kind of an example. Like this is the camera. Mr. Big Sexy up here himself will be teaching with this computer turned around. So like the people on Zoom could see me. It's the same thing as it is today. I'm just standing instead of sitting pretty much. And then I do a lot of practice tests and don't give up, kid. That's the motto. Julian's actually one of my teachers right now. Shelby's a member of the bar. Some people, have had really great results in this boot camp. So it's live in Coconut Grove or virtual on Zoom. In Coconut Grove, it's right across from in between my house and my gym conveniently, like on Bayshore, by the Regatta Club, if you know where that is. It's a hybrid course taught by me. Seats are limited. It emphasizes simulate, practice, and review. So what that means is like mostly in the morning, you will, from 10:30 kind of come in, say, hey, what's up? By the very latest, 10:45, 11, doing some sort of assignment. Everyone's assignments will be different based on what test you're taking, right? Obviously, there's a lot of alignment, but people who are taking like only MBE will do MBE tests. People who are doing Florida will either be doing Florida essay, Florida multiple choice, or maybe an MBE test, so they're doing both. People doing a UBE, California, whatever it may be. So for in this class, you'll either be doing a Florida essay, Florida multiple choice, or an MBE test from like, let's say 11 to like maybe 1 or 2, 1:45, something like that. Maybe 1, whatever the timing may be. And then we come back and we do reviews. We go over things you got wrong. We kind of, go around. I put you in little breakout rooms too. It's a lot of like review. It's a lot of simulation and review. And then, Friday or like Thursday and Friday for 3 of those days, we don't do simulate tests. We just do like almost like a summer camp type shit where it's like, I'm working my ass off to help people really tune up for the test. I have my staff involved. So all the essays are graded like the very next day, not by me. I grade all the essays in this classroom, but in the boot camp, all the essays are graded by, my tutors. And, we have lots of practice Florida multiple choice tests. I would say the number one reason to do the boot camp is because you lack a discipline, right? On your own, you could do this boot camp. Just get yourself a bunch of dope materials and do the same thing. Wake up and by, a certain day, 3 hours of testing, take a little lunch break or whatever, snack break, and then go do a thorough review of it. And then, go home and study, do a whole second day. But that's the first day shift is like a little boot camp. Second day shift is like, study, practice questions, whatever it may be. But you could probably do this on your own. Would it be as effective as if I was leading the way? No, because I'm forcing you to do this. The other students are going to do it. You're like not going to be able to go outside and like take a walk around the park when you should be doing your practice test because you're either in the chair or you're in front of the Zoom and you have to turn it in exactly when the time is done and you're going to get the grade. It's like, it's a pretty solid thing. I think y'all saw Bruna who came in. She's like the TikTok star, and she didn't come to my course. She only came to the boot camp and she passed. And she'll be the first to tell you that that was a huge reason why. I had Vanessa and Alessandra, these two young ladies. Vanessa actually, and I've known her for a while. Her dogs, Solo and Juicebox. Juicebox is Rosie's sister, and Solo is Rosie's mom. And Ian, her boyfriend or husband, whatever he is at this juncture, is my friend from a long time ago. But yeah, she came to the course, her and Alessandra, and they both passed the exam, and they hadn't come to my courses. So the boot camp isn't only for people who come to my courses. I could take on anyone, but yeah, obviously the people who come to my courses, they're the ones who are the sharpest. They're the ones who you've seen come back to the class, like the Angies, the Shelbys, a lot of really great people like Julian, Barbara, a lot of successful people come through my boot camp, and I really put y'all in a good shape. So if you haven't signed up for that, you can still sign up. I think seats are limited, price is only going up. This is USD. It might be more if you pay in a different currency. Um, so yeah, that's the boot camp. All right. Another thing is, oh, I'm a fun person. I've realized that in the world of Chat GPT, the only thing I could do in AI world is be more of myself, because robots are coming for all your jobs. They're not coming for my job. As long as I can stay funny, call myself brilliant, and have these little moments. No reaction from that there. So, okay. This is called the album of the summer, Simon. Nat, I am counting on you to participate here. This is totally optional, but there is a correlation between participation and passing, right? I'm just gonna definitely say that. So the album of the summer it should have an artist name and album title.
Yeah, but this should be album of the winter.
Oh, I called it album of the year. I already changed it. Album of the year. It was called album of the summer. It is called album of the year. It's
Okay.
not. I didn't want to do winter. It's called album of the year, so it's even more grand. I could call it album of the century, but I don't know why I call it album of summer. That just is like the hottest thing, but this is the coldest thing. We gotta keep it moving. So album of the year assignment, artist name, album title. It should teach or reinforce a legal concept tested on the bar. I'll give you some examples. So this is unjust enrichment, restitution, and this is one of my guys, Zach. He's a super cool guy. He's gonna come and talk to the class probably for the MBE, but he kind of stole my whole Riz thing, like unjust, not Riz thing, but unjust enrichment. That's kind of my angle, but I like him. He's the man for that. So unjust enrichment, and then you can also see, I think Zach left a great review where the bee's knees. He was a multiple read time taker, and then we came in with the fresh approach. Investing in your future is the best investment you can make. Like, we love Zach, so that's a cool moment. And then I think we got to see some other albums from previous years for sure. So Grace, we got exclusive squatter. Grace crushed the MBE and is about to pass Florida. So we love Grace. She's a huge example from Puerto Rico. Squatting, adverse possession, right? You have to be open, continuous, exclusive, adverse, and notorious. So exclusive squatter, you think of Grace squatting when you think of adverse possession. JMOL and renewed JMOL, it's like no reasonable juror could find, and then you might have to bring it back on the second time. So JMOL in Florida is what, does anyone know what they call JMOL and renewed JMOL?
Directed verdict.
And then what's the second one called?
Um, Did it delayed directed verdict?
Belated, but all the same. But here's the standard. Who is this? Does anyone know? Is this a celebrity or just a picture? All right. Pillow Talk, Barbara, we love Barbara. I'll definitely have her come in. If you've been using her outline. She's the student who got like a perfect score on Silver Procedure. She actually moved from California to Miami. I met her working at this music festival I work at every year for some reason, somehow, Ultrafest. She was there, and I saw her the last 2 years there. And now she lives in Miami. So she's a major success story. Why do we call this Pillow Talk? Because it's the marital communications privilege. And what does that mean? It's like in Florida, they don't have the testimonial privilege, but they do have the communication. So sanctity beyond bond, not even past death, third party problems, me versus you. This is pretty cute, right? We like this. We like Barbara. Barbara's awesome. All right. See, I told you. You thought, Nat and Alex, that I was joking about Taylor Swift coming to class, but here she is. Reputation evidence, Taylor Swift, Florida's version. Victoria, can you explain this one to the class?
Yes. So Taylor Swift has an album called Reputation, and when she was like doing the advertisement, like advertising it back in, I think it was 2018 when the album came out, she was saying like the tagline was there'll be no explanation, only reputation. So now, like how I remember is like there will be no opinion, there will only be reputation. And then the Florida's version is because Taylor's re-recording all her music. So the Taylor's version is the one that she owns the masters to. So this is just Florida's version since it's not federal.
Taylor Swift, she's amazing. I was with a friend yesterday, and it came on the radio, and he was like, "This song is so deep. Like, she's talking about it so much." And it was like she's the anti-hero, that song. Yeah, it was like the stepmother like pulls out the will, and she's like laughing up in hell. We're like, these lyrics are crazy. But anyway, She's an amazing reputation. Florida only allows reputation evidence, but not opinion evidence. I have to bring Lexi to class. That's what I meant, Nat and Alex. I have to bring Lexi to class, the one who made this album cover, not Taylor Swift herself. Taylor, I don't know. She was an Eagles fan, and then she started dating the Eagles player's brother on the Chiefs. So I think she switched.
She definitely switched.
I know she definitely switched. Trust me, the NFL has made it really aware who she roots for. I was just kidding. I know she switched. All right, so warrantless search. But I also am very careful to say anything that can be construed as negative towards Queen Taylor herself. Like she can root for any team she wants. Honestly, if she played football, she would probably throw a perfect spiral, score a touchdown, and stop and frisk, plain view doctrine, automobile exception, consent, exigent circumstances, search engine to a lawful arrest. This is warrantless search, Fourth Amendment. This is more my jam right here. Does anyone know why this is Jay-Z here? Does anyone get this?
99 Problems.
Yeah, that song 99 Problems. He talks about I know my rights. You gotta have a warrant for that. You're gonna need a warrant for that. Like, pull me over and glove compartment type activity. His album was called Reasonable Doubt. It was kind of like a recognition of maybe his troubled past. But he made it from the cop car being behind him to now the cop cars are surrounding him as he has his entrance into the concert building. So we wouldn't remember the mnemonic spaces, right? SPACES. So this is cool. You can make an album cover related to that. So those were some of the ones from July 2023. And then let's see what was going down in February 2023. Oh, wait. I don't think y'all saw mine from July 23. Yeah, you gotta see this one. Okay, this is Quantum Merowit. So Ill-Gotten Gains is my name. If y'all didn't know that, now's your moment of recognition. Ill-Gotten Gains is actually my rapper name. I haven't released any music yet, but like LaMelo Ball, I'm just gonna come out swinging when my first song drops. So Quantum Merowit is actually one form of like, theory of restitution where you receive services or something that you shouldn't have received and they're gonna have to be paid for an action of quantum merit. One of my students asked me, they're like, Andrew, what would you look like without a beard? Well, now you know, right? That's what it would be like without a beard. So the answer to that question. Okay, that was that album cover. Let's see February. So if y'all know Sam is one of my instructors. Well, not instructors, she's one of our customer service representatives. And she helped me do the essentials course for the last few years. So Attractive Nuisance, her diva name, and Broken Trampoline is her album cover. Sam is a super inspirational story. That's why she joined the team right away. I was like, I need you to join the team. You're an inspiration. She had passed on her 5th attempt, working full time, raising 5 kids. We love Sam. And look, she was a participant in the class. She made the album. I told you there's a correlation between album covers and passing the test. This was the original album, I think. Ill-Gotten Gains Restitution. I think it went triple platinum. You probably have heard it a million times, but I'll tell you something I was thinking about today when I decided to do this album cover announcement. This picture was taken in January 1st, 2017, like New Year's Eve. I was with my 2 friends. We were on top of the Clevelander, if you know what that is, on Ocean Drive. Used to be a different vibe there. And it was New Year's Eve, 2017. The first time I ever took a bar exam was February 2017, right? So that was a month and let's say 7 weeks before the test. Does that look like someone who was nervous about an upcoming exam, right? Or does that look like someone who was confident that, it was just a test, if you master the material, things would go just fine, right? So that's the vibes, right? Sipping on that Dom, smoking a cigar, thinking, man, I'm gonna do really well on my test. I don't think that's exactly what I was thinking in that moment, but ill-gotten gains restitution. Why? Because that's what restitution is for, to disgorge ill-gotten gains. When one party, they get paid a deposit, but they shouldn't have received that deposit. Okay, in an act of restitution, we're gonna disgorge those ill-gotten gains. So hopefully y'all remember that. If you remember one thing about me, that was my rapper name, ill-gotten gains. This is Joel. So you also use a lot of Joel's materials. I really highlight Joel and Barbara's outlines because they did so amazing on the Florida multiple choice section. No coincidence, they came up with album covers. So risk of loss, ECE, equitable conversion, right? Like I had to explain that to me multiple times, but it was like easy E, ECE, equitable conversion, risk of loss. So like That's that concept where the risk of loss passes to the buyer after the contract is signed, but before the closing. So during that period of escrow, we have a, you know, equitable conversion. And then this one, quantum, oh no, sorry, this one, quantum mirror, that's my album. This one, strictly scrutinized sus class, right? This is a talking about con law, right? The suspect classes. Anyone out there feeling pretty confident? Anyone feeling confident? How about you, Sean? You seem confident. You
Okay.
wait there.
For
All right.
con law?
I have a question for you. What is the level of scrutiny for suspect classes, or if it's strict scrutiny? What's the definition? Like, what do they need to prove, and who needs to prove it?
Necessary and compelling, and government has to prove.
Excellent. Well done. Short and sweet. What if it's an intermediate scrutiny?
Um, Important, substantial government.
Nice. And what if it's rational basis?
Uh, the plaintiff has to prove, so normally not the government, and rationally related to a
Exactly.
legitimate interest or
Amazing.
language.
Amazing. You look like a man ready to pass. You look like you should have a three-piece suit on, smoke a cigar on a rooftop. Okay, so this is
Oh,
a really
and quick question, along with the normal federal one, disability is the one that's added for Florida, right?
yeah,
For the strict
disability
scrutiny?
as a suspect class in Florida. Yeah, so race, alienage, national origin, and disability in Florida. So this person, May, she came up with this album. May, I think, went to Yale, or I know an Ivy League school. If it wasn't Yale, it was definitely an Ivy League school. And I think she fell short on her first attempt. And then she came to us, and this is what she had to say. She absolutely loved her experience with IBIS Prep. She worked with Robert and Andrew while studying for the Florida bar exam. She signed up for the weekend crash course. So I used to only do this on weekends. Now you get to see me 6 days a week. I taught by me. I worked with Robert, one of the tutors. So Robert's, I think, still has some availability. I mean, I'm not sure. The combination helped her really well. She was working full time while studying. So having several weekly meetings with Robert, as well as the course on the weekends, helped me stay on track with her progress. The weekend, now y'all do more than that. Course was really useful. Andrew had creative ideas that made it fun. He also cultivated a supportive community. My sessions with Robert allowed me to talk through concepts. I was able to feel myself becoming more familiar, more confident with the exam. Overall, IBIS Prep is amazing, right? So I was just pointing that out to be like, look, if any of you are feeling a little bit nervous or whatever, obviously the solution is just to make an album. No, you should think about either doing tutoring with one of my tutors. You should think about coming to the boot camp. Like, these are things that I really think would be helpful to people down the stretch, right? Yeah, I think those are all are there any more album covers? Oh yeah, a few more. So I'll go over these pretty quickly. Sorry, I gotta see them. All right, so this is governmental taking, right? Bitch better have my fair market value. Take me by possession or regulation. So possessory or regulatory. Possessory per se, featuring physical or constructive. I don't really know what that means. Regulation at Penn Central. So the Penn Central multi-factor balancing test, considering the investment back expectations of the owner based on the regulation, their economic diminution in the value of the land, things of that nature. Oh yeah, that's what she's saying. Economic impact, E impact, and G purpose, general purpose. All right, this one has some thought to it. And this student definitely passed. I remember her now. Your public use of me seemed rational, right? Rational use. Exactly. You were an exception, like a prop take, and then an NVA, a non-conforming use, variance, and amortization. That's pretty good and pretty clever. She passed this test. I don't think she left me a Google review though, so the love is there, but not like super. All right, it's still super. It's just that like the super triple love. All right, so separation of powers doctrine. This is pretty solid. Prevents one branch from having all the power to ensure that each branch can check and balance the others. So legislative, executive, judicial. So I like to use these words on essays, and I think this is Maria, right? And Maria, yeah, Maria's still with us. Maria, grandmother, she's been working really hard. I got a notification that said Maria had completed the Florida multiple choice Q bank. So like we keep tabs of that. She should even got a certificate allegedly. But like I know she's working really hard. We're really proud of her. And this is really a great album. Does anyone know what this album is actually referencing? Which album in music history? And anyone know the band? Really? I guess, I mean, I'm young. Let's see. You don't know the sticky fingers? Oh wait, maybe I'm wrong. Actually, I don't know why I thought that was a reference to that. Maybe I have no idea. It was a mouth, not that. Okay, I'm an idiot. But where is this? Okay, I don't know why I thought that was a Rolling Stones reference. Okay, but it's encroachment, entanglement, entwinement, usurpation. These are all things we could associate with the separation of powers doctrine. All right, good. I thought that was a reference to like my dad's music, but fortunately, I don't know my dad's music that well. Okay, so depraved heart, reckless disregard, right? This is kind of eerie, right? This is murder, depraved heart, reckless disregard. Actually, you know who made this was Monique. So Monique was referred to me by a chain of students that I keep I'm fortunate to work with. Monique, Murder Mo, that's her nickname. Murder Mo is pretty cool. I think Murder Mo and Ill Gotten Gains are two of the coolest names so far. This one, can't forget this one. Invasion of privacy, intrusion upon seclusion records, peeping Tom, right? So intruding upon someone's seclusion, right? Like the way that Victoria tracks Nat's movements inside the house. There could be an argument for that. Intrusion upon seclusion. Florida recognizes the torts of intrusion upon seclusion, appropriation, misappropriation, and then public disclosure of private facts. Florida does not recognize false light. All right. There's actually more from last administration. I guess I've been really doing this for a while now. But shoot, there's even way more. All right, so this is the good faith exception, probable cause, right? You could have good faith. If you don't have probable cause, it's advised, but you could still go in unwardened if you have good faith. She'd definitely pass. Little F and G. Let's see what this was. Prior incriminating statement exemption. What you say? Yeah. What you say? I know that song. That's a throwback. Who is this artist right here? Does anyone know his name? This guy, what you say? All right. You guys don't know your music that well. So severe emotional distress, Florida bar examiners making you take this test, right? I like this one. It was like drawn out. IED, outrageous behavior, 135.5, and she's all sad. I think she was saying that they discriminate against Yankees, like people from the north, I guess. Gabby passed Florida. Gabby was in my class. She's about to pass MBE too. We love Gabby flexing with the dollars. So taxing and spending, plenary power, right? We like that. And then assumption of risk, affirmative defense, including plaintiff knew or should have known of the risk and voluntary proceed in the face of the risk, and objective standards record production. All right, pretty solid. There's actually a whole another album this past year, but I have to find it. It's not uploaded yet, so I'll spare you all that for right now. For those of you guys who weren't enjoying this as much as I was, but that's the album cover assignment. You're more than welcome to submit an album cover. I think you really get the gist of it by now, right? But yeah, that's so far. I really encourage people to submit the assignments, 2 essays for contracts, 2 for torts, 2 for common law, 2 for property, and then for Civ Pro, Crim Pro, and Evans, you know, do all the multiple choice questions. I'm going to try and go through as many of them right now as I can, so that it should be pretty much easier when you do it yourself. Okay. I showed you the reviews. I showed you the boot camp. All right, cool. The last thing is this right here, our Florida multiple choice QBank. You are all now potential ambassadors of IBIS Prep. I'm not saying I'm the best to ever do it, but I'm just saying I don't know anyone out there doing it quite like us, right? And we sell products, we have services, and we just really go hard for our students. People love us. We only have 5-star reviews, and you can really, you know, believe in what we do. So if you know anyone who could utilize our services or whatever, reach out to Alexis or James, one of your customer service representatives, ask them how to become an ambassador. It's just like, you know, 15 minutes of training or whatever. And then anytime you refer a student, you refer a product, you refer a service, whatever, you'll get commissions. We do some really solid commissions. We do actually cash USD commissions that are actually significant. So that's a really great recommendation that I have for y'all. Okay. So the one that, you know, the product that's popping off the shelves right now, I think, is the Florida Bar MBE bundle. You can do all the questions, Florida multiple choice and MBE questions. Think I loaded it up so we can start from square one. Hey, what's up, Vicky VIP? You joined us? Amazing. Well, her and I actually have done all of these together, so it's going to be really great for her. Refreshment, she should be like getting them all right and review. For some of you who haven't done them yet, I encourage you to do them on your own, but like really master these questions. Remember the FBBE practice questions are the ones that you should do over and over and over again. Those are like the most similar. These are going to be to reinforce concepts. And then on top of that, I've assigned additional questions that if it were me, I would spend the rest of my weekend or today, at least trying to run through those questions. All right, let's try the Florida civil procedure questions. So at the close of the pleadings, both the plaintiff and defendant have made sworn motions for summary judgment. Which of the following statements is correct? This question comes down to two answers. And answer C says that since both parties have filed summary judgment, then it should be granted. And answer D says since both parties since they filed summary judgment and they're not contradicted and show no genuine issue of material fact. So D is a better answer than C here because D just says that both parties have asserted no genuine dispute of material fact, where D actually says there's no contradiction. It's not just like, hey, we're saying there's no material fact. It's like there really is no genuine dispute of material fact. And then these aren't the standards. The standards for summary judgment at Florida and federal law, unless someone tells me otherwise, as of like 3 days ago, is no genuine dispute of material fact. So pretty solid. You guys can put your answers in the chat too at the end of this one. In a civil case in Florida, a defendant discovers that the court lacks SMJ over the case. Which of the following statements is correct regarding the defendant's ability to bring a motion to dismiss for lack of subject matter jurisdiction? The defendant can bring a motion to dismiss for lack of SMJ only before the case is filed. The defendant can bring a motion to dismiss for lack of SMJ only within a certain time period after being served with a complaint. The defendant can bring a motion to dismiss for lack of SMJ at any time during the proceedings after the case has gone to trial, or the defendant cannot bring a motion to dismiss for lack of SMJ once the case has been filed. So what do we think the answers are? I appreciate y'all waiting until I read the answer choices, but what do we think? When can we bring this motion for SMJ? Yeah, everyone's saying C. I agree with y'all that we can bring it anytime, right? Remember, motion for SMJ can be brought anytime. It's one of the 12B motions, but SMJ does not need to be brought as first opportunity. It can be brought at any time. All right. What is the time limit for serving a defendant with a summons and complaint after filing the initial complaint in a Florida civil case? 60, 90, 120, or no time limit? What's the answer here? 60, 90, or 120, or no time limit for when you can serve a defendant with a summons and complaint after filing, right? So you file it, and then how long do you have to serve it? What if the answer was federal? Does anyone know what it would be if it was federal? I switched the question. What if it's a federal case? What's the answer? Anyone? Yeah, it would be B.
90?
It would be 90 if it was federal, so let's click 90, but it's not. It's Florida. Florida's 120. Can we all memorize that? That's just a simple thing. Get it, got it good. 120 days in Florida, 90 days in federal. Safwan, can you bring up SMJ on appeal in Florida? Yeah, I mean, I think you can bring it up
At
anytime.
any time.
Yeah.
Yeah.
Okay, so John filed a civil lawsuit against Mary, but voluntarily dismissed the case. A year later, John filed the same lawsuit against Mary and voluntarily dismissed it once more. What's the effect of two voluntary dismissals? The two voluntary dismissals have no effect on the ability to refile. The two voluntary dismissals operate as dismissals without prejudice, allowing John to refile a lawsuit at a later time. The two voluntary dismissals are considered adjudication on the merits, preventing John from bringing the same claims against Mary in the future. The effect of the two voluntary dismissals depends on the specific circumstances of the court's discretion. So what's the effect of two voluntary dismissals, right? Two voluntary dismissals will operate as adjudication on the merits. Adjudication on the merits is the same as with prejudice. With prejudice, all this is claim preclusion. Once there's been two voluntary dismissals, it's considered adjudication on the merits. You're not going to be able to bring it up again in the future. Mark initiates a lawsuit in Broward County against Neil and subsequently voluntarily dismisses it before any answer is filed. After 1 year, Mark once again files the same lawsuit in Broward County against Neil. I'm going to just explain this one to everyone. Following 30 days of silence from Neil, Mark voluntarily dismisses the case. After another year, Mark files a lawsuit in Orange County over a claim originating from the same transaction that led to Mark's two previous lawsuits in Broward County. Which is the most accurate answer? This is a really convoluted question, but let's see what happened here. Mark goes against Neil the first time, then dismiss. All right, let's keep track of that. Mark files and then dismiss. Then Mark files again and then Mark dismissed, right? So Mark has filed and dismissed 2 times. What's the effect of that? Claim preclusion, adjudication on the merits, involuntary dismissal with prejudice, right? You can't voluntarily dismiss twice. But what happened here? After another year, Neil files a lawsuit in Orange County. Can Neil file a lawsuit? Certainly, because remember, claim preclusion, it has to be the same party, same configuration. So A versus B, A versus B. So yeah, A is precluded. But now B can certainly file against A. What's B precluded for? B never had a chance to file a compulsory counterclaim or anything like that. So B would have a chance because they were both filed before any answer was filed, right? No answer was filed. There was no compulsory counterclaim opportunity. He's going to be able to bring it. So Neil's claim is compulsory counterclaim and it wasn't raised in initial action is now barred. No, there was no opportunity. Due to the compulsory counterclaim, Mark cannot dismiss. A year has passed and both claims are now barred by failure to prosecute. Incorrect. Neil's compulsory counterclaim is not barred despite being raised. Not being raised. Only Mark's claim is barred. I love that answer. Neil's compulsory counterclaim is barred by Neil's default in Broward County as the time limit for filing an answer is 20 days. No, it's going to be C here. It's going to be that just because the claim was filed twice by party A doesn't and party B never answered and there was no opportunity to have a counterclaim, it's not going to be precluded in the subsequent litigation, only the initial claim. In a Florida civil case, y'all can answer this. When may a plaintiff amend their complaint as a matter of course without leave of court? Before the defendant files the answer, within 20 days after serving the complaint, within 30 days after serving the complaint, or any time before trial? Yeah, A is the best answer here. Before the defendant files their answer, you can without leave of court. Yeah, A is the best answer here. I could see an argument for B, honestly, but A is the best answer here. Before the defendant files their answer, in a Florida rules of procedure, defendant may amend their complaint as a matter of course before the defendant files their answer. So as a matter of course, you're allowed to do it anytime before they answer. The reason why I guess B is not the best answer is because what if they had already answered? Then it kind of would preclude that. So fair enough. All right. In a civil proceeding, when P, the plaintiff, serves D, the defendant, with a complaint, D must respond with a certain time frame or face default judgment. Assuming D has not requested an extension, what's the typical period D has to file response? 5 days after the complaint was served, 20 days after the complaint was served, 30 days after the complaint was served, or 60 days after the complaint was served? Yeah, Cindy, you're the only one participating right now, but I think Cindy's right. All right, Cindy, you're banned for like 3 questions. If you get banned by me, it's a privilege. It means that you're doing so amazing that I have to ban you. Okay, so 20 days after it was served, we'll go with B. Amazing. Okay. So plaintiff P files a lawsuit against defendant D alleging negligence. D believes that third party T is actually responsible for any potential damages. Which of the following actions can D take to involve T in the lawsuit? File a counterclaim against P, file a cross claim against T, file a third party impleader complaint against T, or file a motion to dismiss against T. C, right? C. So if you think that another party is responsible, but they're not in the lawsuit, it's going to be C, an impleader. And the way to get an impleader is actually a third party complaint. You have to file a complaint against them. It wouldn't be A or B because it's not a party to the case, right? That's counterclaim or cross claim. It's going to be C, third party claim. Motion to dismiss is like, that wouldn't really get your point across. Good work. All right. In a Florida case, what is the maximum number of interrogatories a party may serve on another party without leave of court? 15, 25, 30, or 40? You're all saying C?
Yes.
Are you sure it's C? You guys are sure?
Yeah.
All right. Good job. I had to think about it, but yeah. In federal, it's 25. Someone can look that up. I don't really remember. But I think in federal it's 25. That's why I had to think about it. But yeah, okay. In Florida, it's 30 is the maximum number of interrogatories a party may serve on another. Amazing. In a Florida civil procedure, which of the following is a valid ground for motion to dismiss? The defendant's residence is outside the state of Florida. The plaintiff failed to properly serve the defendant with a summons and complaint. The defendant believes the claim should be handled outside of court. The court is experiencing a high caseload and wants to expedite the proceedings. Yeah, I like B. They improper service, right? Motion to dismiss these 12 Bs, like improper service, improper process, improper venue, subject matter, personal jurisdiction, or maybe insufficient claim or failure to join a necessary indispensable party. Good work. In a Florida civil case, which of the following is not a proper method of service by publication? Posting on the courthouse floor, posting the notice in a newspaper of general circulation in the county where the action is pending, posting the notice on a designated public website, or handing the notice to the defendant's neighbor, which is not proper. Yeah, handing it to the defendant's neighbor is like the dumbest thing I've ever heard. In the civil trial in Florida, what is the effect of the denial of a motion for directed verdict on the jury? So they denied the, directed verdict, the JMOL as it's called in federal. The denial of the motion for directed verdict discharges the jury and a new jury is impaneled. The denial of the motion for directed verdict requires the jury to reconsider the previous verdict. The denial of the motion for directed verdict does not impact the jury and the trial continues with the same jury. The denial of the motion for directed verdict leads to a mistrial and a new trial with a different jury is scheduled. Yeah, they denied the motion for a verdict, so case goes on, right? I like C. The case goes on. If there's no verdict for directed verdict, the case goes on. All right. There's no football today at all, right? Because the games are tomorrow and then college football is over. It's officially fishing season, but it's like, hold out. That's what they say. In Florida, there's football season,
Yeah.
fishing season. But it's too cold to fish. I don't even really like fishing. I rather like watch football. All right, under the Florida rules of civil procedure, I don't hate fishing. It's nothing against fishing. Don't cast me as an anti-fisher. Get it? Cast. Under the Florida rules of civil procedure, when must a party file a motion to challenge personal jurisdiction? Before filing an answer or in the first opportunity, such as a pre-answer motion, within 10 days after filing an answer, within 20 days after filing an answer, or at any time before trial. Right, A is the best one because it's PJ. So PJ is waived if not brought as first opportunity, meaning like a pre-answer motion or in the answer. Sweet. So proof of service is required only when the opposing party is represented by a lawyer, is used in all pleadings and motions when service is by mail, is required only when the pleadings are served upon a non-resident defendant, and serves as prima facie evidence of service. Yeah, proof of service serves as prima facie evidence of service. You could literally get this question on the actual exam. Like proof of service serves as prima facie evidence of service, period. No more, no less. In a Florida civil case, which of the following is not a proper ground for motion to transfer venue? I think this is actually the hardest question that we do today. I've gotten this wrong myself before, and I think I wrote it, which is crazy. In a Florida civil case, which of the following is not a proper ground for motion to transfer venue? Convenience of the parties and witness, the interest of justice, lack of personal jurisdiction, or the court's calendar. So I think this is the hardest question on the test, and I think that Sydney is onto it. Sydney definitely probably did these before. I think it's C. Right? The reason why, and this is the proper argument, is lack of personal jurisdiction is not a reason for transfer. That's a reason for dismissal, right? If you don't have personal jurisdiction, they dismiss. They wouldn't transfer for lack of personal jurisdiction. They could transfer venue potentially, to another proper venue if it was in the interest of justice, but they couldn't transfer if there wasn't personal jurisdiction, right? So the interest of justice could actually include the court's calendar. So very tough question. Venue and jurisdiction are distinct legal concepts. A motion to transfer venue would not typically be based on a lack of personal jurisdiction. So really tough question. If you want to argue with it, the birds outside are flying, maybe they'll argue back. Okay, which of the following is not a recognized method of service process on an individual in Florida? Personal service, substitute service, service by publication, or service by telephone? You like that? Argue with the birds? Service by telephone. My grandfather was a bird aficionado. As I gotten older, I want to learn more about birds. Apparently there's an app, and that's what my brother was saying. The app will just listen to chirping and can tell you, like, you just put your phone out and they'll hear chirping. I'm like, oh, there's this bird, that bird, this bird. Like, I don't know if I believe it or not. So in Florida, a party must file a notice of appeal within how many days of the entry of the order of judgment being appealed? 30, 45, 60, 90. Appeal. Yeah, I think 30 days. 30 days for appeal, right? 30 days for appeal. .110, a notice of appeal must be filed within 30 days. 30 days for appeal, right? If you've never done these questions before and the last time you did, you're like, oh, who cares? I'm not going to get the ones right that are numbers. Well, might as well try and learn them now, try and learn something today. Try and memorize something. So creditor owns Whiteacre. Bobby visits Whiteacre to claim an overdue loan payment from creditor. Creditor refuses to pay, and Bobby repeatedly knocks creditor on the head. Bobby sues creditor for the payment and also files a notice of lease pending on Whiteacre. Moments after creditor's motion for summary judgment is dismissed, Bobby files a notice of voluntary dismissal. The impact of the notice. So this is straight from the, it's just a thing to remember. The impact of a notice of a lease pendens is to automatically cancel. I'm sorry, the notice of a voluntary dismissal is to automatically cancel any lease pendens on the property, because it's like there's no more litigation on the property. If you voluntarily dismiss the case, then the lease pendens, which is notifying people of the litigation on the property, is automatically canceled. So the answer to that one is going to be C. The only reason I'm kind of going a little bit ahead is because I want to get through a lot of stuff today. So just, sometimes we got to go fast, sometimes we got to go slow. That's just life. In Florida, according to this rule, what is the maximum time limit after the entry of judgment to file a motion for relief on the ground of mistake, newly discovered evidence, or fraud? I believe it's 1 year, yeah. I believe in a thing called love. 1 year, right? 1 year is the correct answer for mistake, newly discovered evidence, or fraud. There are some things that, and if anyone knows them, they can put them in the chat, where you can do it anytime. But these are within 1 year. And then, like new trial and appeal are way shorter. So if you see something like 7 months later, it's got to be relief from judgment. Which of the following is not a proper ground for motion to disqualify a judge in Florida? Personal bias, the judge prior representation of a party, the judge ownership of stock in the company, or the judge unfavorable rulings against the movement. Obviously D, like just because you've lost it against this judge a million times doesn't mean you can disqualify him. Just means you're probably not a good attorney, or just like, it's just not your jurisdiction. You should move away. In Florida, when can a plaintiff typically serve the process on, who can they serve it on when suing a corporation? The corporation's registered agent, employee at the corporation's principal place of business, the corporation's mailman, or the corporation's customers? Yeah, definitely the registered agent. That's the proper person when you're serving a corporation. If you can, serve them. What's the maximum number of peremptory challenges each party is allowed in a Florida civil case, assuming there's only one plaintiff and one defendant? 3, 4, 6, or 10? Yeah, I think we're rocking with 3, right? 3 peremptory challenges per party if it's only 1v1. In a civil case, the defendant is preparing his closing arguments when he stands and he dismisses it. The defendant protests on the grounds that the court previously denied the motion for summary judgment, and the plaintiff had previously dismissed the same case before. So he dismissed it twice here. He dismissed it once, dismissed it twice. If the facts are true, 2 voluntary dismissals will operate as adjudication on the merits. So he's telling me dismissed it, but it'll be with prejudice, right? The trial will proceed because the plaintiff cannot voluntarily dismiss. No. The trial will stop because he can dismiss. No. The trial will proceed because he cannot dismiss. No. He can dismiss right now, but it'll be with prejudice because it's the second time. Does anyone disagree with me here? Is D? I might have gone too fast, but I think that's what happens. All right, good. Right, you dismiss it twice, the 2 dismissal rule. Make sure you learn that today. 2 dismissals are adjudication on the merits. That's going to be the effect of claim preclusion. Which of the following is not a valid basis for seeking a preliminary injunction in Florida? To preserve the status quo, to prevent irreparable harm, to punish the defendant for contemptuous behavior, or to prevent the plaintiff's likelihood of success on the merits? What is not a valid reason? It's not to punish. Injunctions are not to punish. Injunctions are not to punish. A few days prior to the scheduled court hearing in a civil lawsuit, defendant thought about filing a motion to dismiss the case. Defendant had never filed such a motion before. Defendant was aware that plaintiff would likely file a motion for default judgment as soon as the court hearing took place, which is true. Defendant can file a motion to dismiss without seeking court's permission, but the court may impose costs on defendant. Defendant can file a motion to dismiss without seeking court's permission, and defendant would have to pay costs only if defendant presented the same defense against plaintiff again. Defendant would be subject to pay costs only if the court approved a dismissal with prejudice, or defendant would be subject to pay costs only if plaintiff succeeded at trial. Can you dismiss, right? Is the question. Okay, good. This is the last Civ Pro one I'm gonna do for the day. Unless we have time to do more. Yeah, I agree with Sydney. I think you're back. By the way, Sydney, you're unbanned. I think that you can dismiss. Why not? You can dismiss it, but they're gonna impose costs on you if you dismiss it at this time, right? It's just a few days sooner. Like you're allowed to dismiss it, whenever, but if you dismiss it this late, they're gonna impose costs on you. All right, that was pretty solid. If we have time to do more Civ Pro questions, we will. Any questions on Civ Pro so far about anything we did? You guys learn it? Did anyone learn anything? What's one thing that someone learned that they didn't know before? You all got one question wrong, so you had to learn one thing. That personal jurisdiction is more valid reason to dismiss, not change venue, right? Okay. Well, if you're not learning anything, that's even better. That means that you know everything so far, and knowledge is power. All right, let's do some Crim Pro ones. So what's the standard of proof required for criminal conviction in Florida? Preponderance of the evidence, clear and convincing evidence, beyond a reasonable doubt, or probable cause? Yeah, beyond a reasonable doubt. All right, Sean, I like what you're doing. I'm looking at you, Sean. I like that. Whatever answer you throw up, I'll see. So beyond a reasonable doubt, right? Because it's the Jay-Z album, right? Giving a lot of shout out to Jay-Z. I hope Jay-Z keeps his name in good standing for the rest of his life. I don't want to support celebrities only to come to find out he was at the Diddy freak-offs. So George was arrested and charged with a felony. Upon his attorney's request for discovery, the prosecution should provide certain information. Which of the following is the prosecution not obligated to disclose? Results of any physical or mental exams, scientific tests, or experiments related to the case, transcripts of grand jury deliberations that led to George's indictment, all tangible documents or items that the prosecution plans to use in court, irrespective of their origin, or the identities and addresses of individuals known to possess information pertinent to the alleged crime. What do they not have to disclose?
Grand jury.
Yeah, the things related to the grand jury, right? Grand juries are secretive, very secretive. Grand juries are secretive, very secretive. I'm only doing that because I'm trying to like reinforce things in your mind, and maybe if I say things over and over again, it'll work.
Does stuff from grand juries only come out at trial if it's used for like impeachment purposes, for like sworn testimony, or no?
I don't think it would come up at all at a
No.
trial.
Okay.
Yeah, it's pretty tough. You would have to get some like protective order. It would have to be really tough to get something out of a grand jury to use in trial.
I was mostly referring to like I thought it was for like sometimes the state will like have witnesses who implicate a defendant and then like they'll go back on what they said in the grand jury and the state I'm afraid I forget whether or not the state can actually do anything about that from their sworn testimony during the grand jury.
That's interesting. That's a good question. I mean, my thought would be they shouldn't be able to, but if that is an exception, I'd like to know about it. So maybe someone could look into that. Could you use testimony from a grand jury to impeach subsequent testimony in a jury trial when it's, inconsistent? Again, my thought would be probably not because it's a grand jury, but if that is an exception, like I said, I'd like to know about it. So. All right, let's see this next question. In Florida, what stage of the criminal proceeding does the defendant appear right after being formally charged with the crime? Arrest, first appearance, arraignment, or preliminary hearing? So they've already been charged here. Now they're going to enter their plea. Where are they going to enter their plea? I'd say at the arraignment, right? Yeah, we'll enter the plea at the arraignment. A lot of this happens together. The first appearance, the arraignment, maybe they'll have the non-adversarial probable cause determination hearing. That could all happen like that. Ooh, that's a good little snap. In Florida, which of the following is not a purpose of bail? To ensure the defendant's appearance at trial, to protect the community, to punish the defendant, or to prevent witness tampering? So to punish the defendant, right? So we learned something. Here's something interesting. The purpose of bail is not to punish the defendant. Similarly, does anyone know a similar analogy we can make based on something we learned in Civ Pro, Florida Civ Pro? What else is the purpose of not to punish the defendant?
Injunction.
Similarly, in civil procedure, the purpose of an injunction is not to punish the defendant, right? A little association. In Florida, who is responsible for determining whether a defendant is guilty or not guilty? The judge, the jury, the prosecutor, or the defense attorney? It'd be nice if it was a defense attorney for the defendant, right? Right? Determine guilt is going to be the, what do we think? Yeah, the jury, the jury. All right, ooh, we have some law in the chat. So, um, Safwan is saying under federal rule 801D1A, prior inconsistent statements may be used for impeachment purposes as well as substantive evidence as long as the requirements of the rule have been satisfied. The statement was inconsistent with the declarant's testimony and the statement was given under oath. So it was under oath, for example, grand jury, witness testimony, deposition, etc., then it can be used for substantive evidence.
Yeah, that's a little different from what Sean was asking. I think Sean was asking more about discovery, like if it grand jury testimony has to be handed over. This question, I think I've seen questions on the MBE at least, and FRE in general that says like prior inconsistent statements can be used for both substantive and impeachment if they're under oath. So if they're under oath, that could include grand jury testimony, but that's a little different from whether grand jury testimony can be discovered.
True, true, true. Nice, man. Okay. Let's do the next question. So in Florida, no contendory plea is also known as which of the following? Guilty, not guilty, no contest, or Alford plea?
See,
C, no contest. Alford plea, that's what that rapper did. You guys know what I'm talking about? I know what I'm talking about. Which amendment to the United States Constitution guarantees the right to a speedy and public trial? First Amendment, Fourth Amendment, Sixth Amendment, or Eighth Amendment? Yeah, this is Sixth Amendment. I mean, this is pretty federal law, whatever. Under the Florida Rules of Constitution, when is a defendant guaranteed the right to bail before trial? In every case, as long as the defendant has not previously been convicted of a violent felony and has not posed a danger to society, unless the defendant is charged with a capital offense, unless the defendant is charged with a capital or non-capital offense where proof of guilt is evident and presumption is great, unless the defendant is charged with a capital offense or offense punishable by life imprisonment where the proof of guilt is evident or the presumption is great. This is heavily likely to be tested, this standard, right? Yeah, I like to hear. It's capital offense or offense punishable by life imprisonment or the proof of guilt is evident and presumption is great. So here, we don't like this one because it says just capital or non-capital, but it has to be capital or offense punishable by life imprisonment. In Florida, what type of jury is responsible for determining whether there's sufficient evidence to charge a person with the crime? Trial jury, grand jury, petite jury, or coroner's jury? Yeah, grand jury. This is, what we were talking about earlier. It's private. We're there to determine whether there's enough evidence to charge them. It's not a trial jury. We know what that is. A petite jury is what it sounds like. Very small jury. And then a coroner's jury. Anyone know what that is? A coroner's jury? That's exactly what it sounds like. A coroner's jury is like a jury that's convened because there's a dead body, and we gotta like figure out what happened here. It's a jury over a dead body. I was gonna make a Washington Commanders joke, but I'm trying to be respectful. Which of the following is a requirement for a search warrant in Florida? The warrant must be based on probable cause. The warrant must be signed by a law enforcement officer. The warrant must be requested by the defendant. The warrant must be issued within 24 hours of arrest. I think A is pretty much warrants are issued based on probable cause, right? By a neutral magistrate, based on information that, adequately describes, the arrest or the what's being searched. In a Florida criminal case, what is the primary purpose of a voir dire? To determine admissibility of evidence, to select a fair and impartial jury, to present opening statements, or to establish elements of the crime. So, to select a fair and impartial jury, yeah. So, a student just texted me that the Commanders decorated the Rocky statue with their scarf and hat. I saw that. I thought that was a joke. Like, I thought you would not be that crazy and dumb to do that. Like, what? That's serious? They really did that? Oh, I got Eagles by 500,000 now. Like, that's crazy. You can't. That'd be like, I don't know. There's no city that has such an attachment to an imaginary character from a movie like Philly and Rocky. I just can't even say. I'd be like Miami and Al Pacino and Scarface or something. At a Florida criminal trial, which of the following is not a permissible challenge to a prospective juror? A challenge for cause, a peremptory challenge, a challenge based on race, or a challenge based on the juror's inability to understand English? Challenge based on race. Yeah, you can't do that. You can't do race, you can't do gender, you can't do, anything that would be a constitutional violation. Equal protection problem. In Florida, which of the following right does a defendant have at arraignment? The right to be informed of the charges against them, the right to enter a plea, the right to be represented by an attorney, or all of the above? Yeah, this is where you do all the above, right? Enter a plea by an attorney, and you're informed of charges against them. Good old arraignment. In a Florida criminal, it's interesting because like I swear a year ago, literally 1 year ago, I was like, yeah, arraignment. That's what Donald Trump is doing right now in Miami. He was being arraigned, and now it's like inauguration. That's what he's doing today. Times have changed. In a Florida criminal trial, which of the following motions would be appropriate to challenge the admissibility of evidence? Motion to dismiss, motion to suppress, motion for judgment of acquittal, or motion for a new trial? So challenging admissibility of evidence, yeah, we're going to challenge it through a motion to suppress. Excellent. That's how you challenge admissibility of evidence. It's going smoothly. When determining whether to grant a pretrial release in Florida, which of the following factors can a judge consider? The nature and circumstance of the offense, the defendant's ties to the community, the defendant's criminal history, or all the above? Yeah, all the above. These can all be considered when considering a pretrial release. The nature and circumstance of the offense, the defendant's ties to community, and the defendant's criminal history. Right? We should begin. I'm telling you guys should be going through my Q bank, and it should be smooth sailing. You should be able to get all these right. And then, when I give you some additional practice tests, whatever it may be, I mean, they'll be tough. We have a 100-question practice exam and a mixed question review. So we have some practice tests, but I have tons of materials that I'll give you. But like, this is the foundation. You guys should be able to cruise through these questions. They were made to support a strong foundation. In Florida, if no good cause is shown for an extension, what is the maximum amount of time a defendant can be held without formally being charged for a crime? 12, 24, 48, 72. Yeah, it's going to be 48. Remember the rule here, 48, 24, 24. These rules are really important. I mean, this is what separates the passers from the failures. I could give you all the best speech. I always do this speech at random times. I've done it like multiple times in my life. That's a really good way to like impress people. Is just memorize a random speech and then just deliver it when no one's expecting it. And then people are like, what are you talking about? But then they realize you're giving a speech that someone already gave. But I'll do an Al Pacino speech from Any Given Sunday. And like it's what separates the winners from losers. There's the difference between living and dying. The 6 inches in front of your face, right? That's what separates the failures from the passers. Whether you understand these little concepts, the 48, 24, 24 rule, 48 hours to be charged or 2 24-hour extensions for good cause, right? So 48, but it says without good cause for an extension. So 48, 24, 24, right? 48, but 2 24-hour extensions. Yeah, that's a good movie. Anyone know a movie I'm talking about? The Al Pacino speech from the middle of the movie, from the halftime. Tom is defending a client in federal criminal trial and would like to challenge 3 jurors for cause. Which of the following would be the weakest challenge? A juror who confirms his absolute readiness to abide by the law, but does so with a seemingly sarcastic tone. A juror who admits that they might be influenced by the fact that the defendant has chosen not to testify. A juror who voices doubt about your client's claim of self-defense. A juror who has previously worked as a paralegal in a law firm specializing in criminal cases. The movie is Any Given Sunday. I don't know how none of y'all know that movie, but that's another Miami movie. They were called the Miami Sharks in that movie, and it was like Al Pacino. It was Jamie Foxx. It was Cameron Diaz. That is a classic movie if you've never seen that movie. So anyway, yeah, we're not going to be able. Well, A is actually a weak challenge. Just because you did it with sarcastic tone, you said you were ready to abide. Like, how do I know it's a sarcastic tone? I don't love this question, but I know this is the correct answer. You said you might be influenced by a defendant. That's bad. You literally doubt the claim of self-defense. You're like already like talking about what the case is. And here you worked as a paralegal. That's problematic. Yeah, Lawrence Taylor was in that movie too. Yeah, that was a really good movie. Really funny movie. So, hey. And the kicker was hilarious. He was wiry. Which of the following would not be an appropriate subject for the judge to inquire into when considering pretrial release? The defendant's pretrial convictions, the defendant's employment status and history, the strength of the prosecution's case against the defendant, and the defendant's ties to the community. So it would not be appropriate for the judge to inquire into. Yeah, it wouldn't be appropriate to inquire into the strength of their prosecution into the case, right? Like you're talking about should they be released or not. So these are the factors: their previous convictions, their employment status and history, and their ties to the community. Excellent work. Holy bananas. This is a really long question, but let's just get to, I guarantee you can get it just by reading this question. Which of the following is Daniel's strongest issue for seeking a reversal? If all the answer choices were true, which one would grant a reversal? The fact that the jurors did not start considering evidence until 7 days after they were impaneled, the fact that the jury was allowed to go home after being sworn, the fact that the jury took several days to reach a verdict, the fact that the jury was allowed to go home after beginning deliberations. If all four of them were true, which one would be the most problematic? Yeah, excellent. Okay, Vicky, I see you're participating now. D would be true, right? That after deliberations, if they were allowed to go home, well, they probably went home, turned on the TV, saw that Jamie Foxx was leading the comeback for the Sharks. When determining whether to grant pretrial release, a judge in Florida cannot reconsider which of the following factors: the nature and circumstances of the offense, the defendant's ties to the community, the defendant's criminal history, or the defendant's parents' criminal history. Yeah, the defendant's parents' criminal history would not be good, right? If I was judged by all the acts of my father, y'all would think I was a real goofball. In Florida, once a defendant invokes their right to a speedy trial, within how many days must the trial begin, regardless of whether the trial is a misdemeanor or felony? 30, 50, 60, or 90? Yeah, once they invoke it, and I think they actually have 60 days to invoke it. That's why a very hard question. They have 60 days to invoke it, but once they invoke it, they have to be brought within 50 days. So remember these rules. 50 days is for speedy trial request, and then 90 and 175. 90 for a misdemeanor, 175 for a felony. So 50 days once it's invoked. 3.19, speedy trial. In Florida, what is a valid reason for granting a change of venue in a criminal case? Inconvenience for the defendant does not like the judge assigned to the case, the defendant does not like the prosecutor assigned to the case, or pretrial publicity and inability to obtain a fair and impartial trial. Yeah, D is the only valid reason. Inconvenience or not liking the judge isn't this, but pretrial publicity and independent or inability to obtain a fair and impartial jury, right? Like if they were trying let's say Michael Jordan in Chicago, they're not going to be able to convict him there, right? Like if they were trying like Saquon Barkley in Philly right now, no one's going to convict him because it wouldn't be a fair venue. The kicker, I don't know. He might. A defendant facing charges of embezzlement shall be provided with a list containing the names and addresses of all potential jurors. When can the defendant obtain this information? So Barbara, who was she did the Pillow Talk album, she was a criminal defendant in California for like 10 years before she came over here and took the Florida bar. And she hated this answer. But this is literally from the FBBE. Like this is literally like a rewrite of one of their questions. So it's true answer. A defendant facing charge of embezzlement shall be provided with a list containing the names and addresses of all potential jurors. When can the defendant obtain this information? Upon court order, upon request and demonstration of justifiable cause, or under no circumstances?
B.
Yeah, it's actually upon request. That's the true answer to this, that they can get your address and send you flowers, right? Prison flowers. Under Florida law, what is the primary purpose of a grand jury? To determine guilt or innocence, to oversee the trial proceedings, to determine probable cause, or to issue a verdict. So grand jury, right? A grand jury is, again, to determine probable cause. That's what we do a grand jury for, right? To determine probable cause. We've done that a lot. All right, let's do one more pro question for now. Under Florida stop and frisk law, which of the following accurately describes the authority granted to law enforcement officers according to 901.1512 of the Florida statutes? Officers can temporarily detain an individual when there's reasonable suspicion that the person has committed, is committing, or is about to commit a criminal offense. Officers can conduct a thorough search of an individual without any specific justification, solely based on the officer's discretion. Officers can permanently arrest an individual without obtaining a warrant or probable cause. Officers are not authorized to stop or detain individuals under any circumstances without warrant or probable cause. Right, this is the stop and frisk. They get to stop, pat you down, and then if they feel, something that feels like cringly, then maybe they can find the drugs or whatever it may be. But they're really supposed to stop you because they believe criminal activity is afoot, and then they could do you know, a temporary detainment, and they could do a little frisk, right? The reason why when this laws came out, there was a lot of pushback was because the argument was that it gave officers, let's call it unfettered discretion, or it gave them discretion of who looked like criminal activity was afoot and who they could stop and frisk. And the argument was that it was more likely that they would stop and frisk minorities than other individuals. But, you know, this isn't a politics class. Thank the Lord, right? Okay, so officers can temporarily detain people when there's reasonable suspicion that the person is committed or is committing or is about to commit a criminal offense. It allows them to briefly detain them, and it's limited to a temporary detention for the purpose of investigation identification, requires suspicion, which is lower standard than probable cause. It does not grant them unrestricted search or arrest powers, right? Just a little frisk. Okay, cool. So if we have time, you know, we'll do some more questions, but let's do some evidence. All right. Which of the following hearsay exceptions requires the unavailability of the witness under the Florida evidence rule? Excited utterance, present sense impression, statements made for the purpose of medical diagnosis or treatment, or statements made against pecuniary interest. Right, statements against interest require the unavailability of the witness. So that the witness is dead, the witness is in a coma, the witness refuses to testify, and they have no memory. Like, not that they're just hostile, but they're just like, they are totally unavailable. They're like out of the country and can't be brought back for whatever reason. Statements against interest do require unavailability. And remember, in Florida, everything is an exception. We don't do exemptions in Florida. A plaintiff alleges that he suffered an injury when a ladder collapsed under him at a construction site managed by the defendant company. In its defense, the company attempts to present testimony detailing its regular safety procedures for inspecting and maintaining ladders on the site in order to inform the jury on the question of negligence. Under the Florida Evidence Code, the evidence is relevant. The evidence is admissible only if it's supported by written safety policy or procedure. The evidence is admissible if it reflects the routine practice of the company. The evidence is admissible only if there's a universally accepted safety standard in the construction industry. Yeah, I agree with the students. If it's true that this is routine practice, routine is admissible. In Florida, we associate routine with a business and habit with an individual, right? In a lawsuit for breach of contract, Johnson is suing Green for damages. Johnson's attorney believes certain parts of Green's deposition would strongly support his case, so he plans to read excerpts from the deposition at trial rather than call Green to the stand. Green contests Johnson's use of the deposition in court. How is the court likely to rule? Johnson may use the deposition at trial, but if requested, he must read all parts that in fairness should be considered alongside the part introduced. Johnson may use the deposition at trial, but only to contradict or impeach Green's prior inconsistent statements or pleadings. Johnson may not use a deposition at trial, as Green is able to testify and there are no exceptional circumstances. Johnson may not use a deposition at trial, as this would make Green his witness and prevent impeachment. So you can use this deposition, right? But you have to read all parts that in fairness should be considered alongside the part introduced. That's the rule of completeness, right? You can't just, you know, bring in a little fraction, right? Under the rule of completeness, if a party introduces part of a deposition, the opposing party can require them to introduce any other part that in fairness ought to be considered with the part introduced. All right, this is a really long one. Let's see what's going on here. It's just gonna go offers to compromise. What do we know about offers to compromise in Florida? They're inadmissible, right? We're not gonna allow an offers to compromise to prove liability. We don't allow offers to compromise or actual settlements to prove the validity or value of a disputed claim. It encourages parties to negotiate and settle, right? These are public policy exclusions. Under Florida evidence rule, which of the following is not a privilege recognized in a civil case? Attorney-client, spousal testimonial, sexual assault counselor victim privilege, or clergy penitent privilege? A lot of answers coming in. We definitely recognize attorney-client privilege. That's humongous. Spousal testimonial is not recognized in Florida. Florida, as we saw with the Pillow Talk album, right? And I swear I have a whole nother administration of album covers. That's how long I've been doing this and how consistent I've been with my foolishness. We had the pillow talk one, which is the marital communications privilege. The marital communications privilege is protected. The spousal testimonial privilege is not protected because that's just not a recognized privilege in Florida. It is in federal law. Sexual assault counselor victim privilege, definitely protected. And then, yeah, we recognize these religious protections between a religious leader and someone, seeking spiritual advice under the sanctity of religious concepts. So I would go with spousal testimonial privilege. Okay. Which of the following is not a requirement for admissibility of a scientific opinion under Florida evidence rules? So does anyone know what standard we use to qualify an expert witness?
Albert, not Fry.
Albert, not Fry. Nice. So which one is not a requirement? The opinion is based on scientific principles that are generally accepted. The expert has applied the principles to the facts of the case. The expert is qualified to give the opinion. The opinion is consistent with the witness's prior statements. The answer is D. I'll tell you, I love these questions. Questions that say to me, I love them for study. When the question says, which of the following is not a standard, and then it gives me 3 answers, and then the 4th one is wrong, they're great for studying. Why? Because totally ignore the wrong one. Like pick the right answer and ignore that. But then you learn the right ones. You learn the 3 things that are correct. So every time there's like one of those questions, it's great to be like, okay, the answer that was wrong, I don't care about. But look at the other answer choices and memorize them because those are the applicable standards. So here, these are the applicable standards for admissibility of scientific opinion. It's based on scientific principles that are generally accepted. The experts applied the principles of fact to the case, and the experts qualified to give the opinion. It's not D. Who knows what D is? That's irrelevant. During a deposition upon oral examination, a party's counsel may instruct an opponent not to answer a question for which of the following reasons. The question asks for information that's protected by attorney-client privilege. The question seeks hearsay testimony that would be inadmissible at trial. The question asks for the opponent's personal opinion on a matter of fact. The question involves the opponent's personal feelings about the opposing party. Yeah, I like A. I like what Judy's saying. It's protected by attorney-client privilege. If something is protected by attorney-client privilege, then counsel will be like, yo, you don't need to answer that. Like you and your attorney said that amongst you and your attorney. That is not something that you need to speak about here. Remember, attorney-client privilege is about communications, not like how much you paid the attorney or like when you parked your car at his office or whatever it may be. During a civil trial, the plaintiff called a witness to testify. During the witness's deposition, they provide a statement that contradicts their current testimony in court. The defendant seeks to introduce the prior inconsistent statement to challenge the witness's credibility. Should the court allow the prior statement to be admitted to evidence? Yes, because any party can attack the credibility of a witness by introducing a prior inconsistent statement. Yes, because a prior inconsistent statement made during a deposition is always admissible for impeachment purposes. No, because the prior statement was not made under oath during the trial, or no, because a prior statement was not made in open court. So this one's tough. I think people are between A and B, right? Like we think it should come in, right? They're seeking to introduce a prior inconsistent statement, right? But the difference between A and B here is any party can bring it in, and B says any statement is always admissible, right? It's always admissible for impeachment purposes. It's not always admissible if it, is let's say overly prejudicial or whatever it may be. But A is true that any party can attack the credibility of a witness by introducing a prior statement. So A is a stronger answer. Alex, what are you talking about? Because the party could attack the credibility of a witness by introducing a prior inconsistent statement. Yeah, right. So yeah, exactly. I mean, these answers are what Alex is saying is true that like there's 2 absolute words in here. It says any party can attack the credibility of a witness, and here it says is always admissible. Both of them gave me pause, but A is true. Any party can attack it. It doesn't matter. You can impeach your own witness, you can impeach the other person's witness, any party can. Now, it's not always admissible for impeachment purposes, right? There could be reasons why it couldn't come in. So under Florida evidence rules, any party in civil trial has the right to attack the credibility of a witness by introducing a prior inconsistent statement. This includes statements made during a depo that contradict the current testimony in court. All right. I'm just happy you're paying attention, Alex. That means a lot. During a criminal trial, the defendant Mark is charged with assault against his spouse, Lisa. Lisa testified that Mark admitted to physically assaulting her during an argument. Mark objects to this testimony, asserting the husband-wife privilege. How should the court rule on Mark's objection? Sustain the objection, as the husband-wife privilege protects all confidential communications between spouses. Overrule the objection, as the husband-wife privilege does not apply in cases involving crimes against a spouse. Sustain the objection unless Lisa willingly waives the husband-wife privilege. Overrule the objection, as Mark's admission of assault is essential evidence in the case. Yeah, we'll see this come up. Like, yeah, good job, everyone. We'll see this come up in the case because we'll see this come up on the test that, like, yes, there is a husband-wife privilege potentially, but not in cases where they're against each other, right? So the court should overrule Mark's objection. The husband-wife privilege typically protects confidential communications between spouses. However, an exception to this privilege exists when one spouse is accused of committing a crime against the other spouse. In this case, Mark is charged with assaulting Lisa, his spouse. As the crime involves a violence against a spouse, the husband-wife privilege does not shield Mark from Lisa's testimony about his admission to the assault. So we kind of learned some things that Florida does not recognize the spousal testimonial privilege, only the marital communications one. And even within the marital communications, it's not always protected if it's like a spouse versus spouse crime case. Under the Florida evidence rules, which of the following is not a requirement for the admissibility of business records? Again, I like these questions. So we'll learn 3 things that are requirements and then one thing that's kind of stupid. The record was made at or near the time of the event it describes. The record was made by someone with knowledge of the event. The record was kept in the course of regularly conducted business activity. The record was created for the purpose of being used as evidence in a trial. D is not only wrong, D is exactly why it wouldn't be admissible. It's why it would be protected. If it was made in anticipation of litigation, it would be protected, not admissible. These are the reasons why it'd be admissible. If it was made by someone with knowledge at the time an event it describes, and it was part of a regularly conducted business activity. Yeah. All right. During a civil trial, the plaintiff's attorney asked the defendant if they made a settlement offer to the plaintiff prior to the trial. The defendant's attorney objects to the question. How should the court rule on the objection? Overrule the objection, as settlement offers are admissible as evidence of liability. Sustain the objection, as settlement offers are generally inadmissible under the Florida rules of evidence. Overrule the objection, as settlement offers are relevant to credibility of the defendant. Sustain the objection, as settlement offers are only admissible if they're in writing. So we talked about offers of compromise being inadmissible to prove liability. What do we think about settlement offers? Same, right? They're generally inadmissible under Florida rules of evidence to prove liability. Settlement offers and offers of compromise, generally inadmissible. Which of the following is not a requirement for the admissibility of a dying declaration under Florida evidence rules? The declarant must have believed death was imminent. The statement must concern the cause or circumstances of the declarant's impending death. The statement must have been made to a medical professional or law enforcement officer, or the witness is now unavailable. Yeah, nice, Vicky. C. The statement must have been made to a medical professional or law enforcement officer. It's not a requirement. The requirements are the declarant must have believed death was imminent. The statement must concern the cause or circumstances of the declarant's impending death, and the witness is now unavailable. So a couple of things here. You have to believe death was imminent. Just because you say something and then whack, you're no longer living. That's not a dying declaration. You have to believe death is imminent. This one, you can't be on your deathbed and say, and Tommy owed me $50, make sure I collect that, right? That's not related to the death. And then the witness is now unavailable. Now, you don't have to actually die, but you have to actually be unavailable. So you have to think you were dying and then now be unavailable. So either dead, in a coma, out of the country, or just somehow unavailable. But this statement is absurd, right? Dying declaration can be anyone. Under Florida evidence rules, which of the following is not a requirement for admissibility of a statement against interest? Again, so these are important. These are the elements of a statement against interest. The statement must have been made by a person who is unavailable as a witness. The statement must be made against the declarant's proprietary, pecuniary, or penal interest. The statement must be corroborated by other evidence, and the statement must have been made voluntarily with a consciousness of its implications. So it's not Yeah, it doesn't need to be corroborated by other evidence. It's on its own. But these are the three requirements. Everyone can listen here. These are requirements of statement against interest. It must have been made by a person who is unavailable. So unavailability is huge for statement against interest. The statement must be against the declarant's proprietary, pecuniary, or penal interest. Penal interest. That's different than a party opponent admission or statement by a party opponent, because they don't always have to be against their interest. They just have to be pretty much a statement made by a party opponent. The statement against interest really does need to be against their proprietary, pecuniary, penal interest. Now, party opponent admissions and party opponent statements usually are, against them, but they don't necessarily have to be. And then it has to be made voluntarily with a consciousness of implications, right? It can't be coerced. So would intoxication knock out D? Yes, right? Yeah, I think so. I mean, that's at least a good argument that if you were intoxicated, the statement wasn't made voluntarily and with the consciousness of its implications. Yeah, I think we all could ask that statements were made when we're intoxicated, not admitted into evidence. Me, myself included. Okay. Which of the following is not an exception to the best evidence rule under Florida evidence rules? The original is lost or destroyed. The original is in the possession of an adverse party. The original is a public record, or the original is a trade secret. So for best evidence rule, yeah, it doesn't need to be a trade secret. It just needs to be something like an X-ray or a photograph or a recording, and it's got to be lost or destroyed. No, these are exceptions that if it's lost or destroyed, if it's in the possession of an adverse party, or if it's a public record, then we don't need to bring in the original. If it's a trade secret, I mean, that would be like a reason maybe not to bring it in because it's protected. We can't bring this thing in. But maybe not actually. But I think, yeah, the best answer here is a trade secret, right? The best evidence rule requires the original document produced unless it's been lost, destroyed, or is in the possession of an adverse party. The fact that the document contains a trade secret is not an exception. So, that's kind of a tough one, but just because it contains a trade secret is not recognized as an exception for why we wouldn't bring it in. The reasons why we wouldn't bring it in are it's been lost, it's in the possession of an adverse party, or it's a public record. Okay. During the criminal trial, the prosecution calls a witness who testified that defendant John told them, "I'm committed the crime and I'm guilty." John's attorney objects, arguing that the witness's testimony is inadmissible hearsay. The prosecution argues that the statement should be admitted as an admission by a party opponent. How should the court rule in the objection? The court should sustain the objection because the witness's testimony is hearsay. The court should overrule the objection because the witness's testimony falls under the exception for admissions by a party opponent. The court should sustain the objection because the witness's testimony is not relevant to the case. The court should overrule the objection because the witness's testimony is a statement against interest. So who said it? That John said it. And he's a defendant. So it's a party opponent admission, right? He literally said, "I committed the crime." I mean, this is the most blatant party opponent admission in the history of party opponent admissions. He's a party opponent, he's a defendant, and he said, "I committed the crime and I'm guilty." And I'm actually making a party opponent admission, right? That was very much admission by a party opponent. Recognize statement against interest, unavailability. This dude wasn't unavailable. This dude was a party. Those are different concepts. Under the Florida rules of evidence, which of the following is not a requirement for admissibility of prior inconsistent statement? I like this. So what are the considerations for a prior inconsistent statement? The declarant must be subject to cross-examination at trial. The statement must be inconsistent with the declarant's trial testimony. The statement must have been made under oath at a trial hearing or deposition, or the statement must be offered to impeach the declarant's credibility. Yeah, this is a tough one as I'm reading it, but I agree with Steven, I think. I don't think it has to be made under oath. I think it's like the red light, yellow light, right? Right? Like you say the light is yellow. Well, now we have you earlier saying it was red, not necessarily in court. Admissibility, that might be substantively, but not just to be admissible for impeachment purposes. A, I think is correct. They do have to be subject to cross. Has to be inconsistent. So B is correct. And offered to impeach. Yeah, that's what it's for. It's a tough question, but I think the answer is C. Yeah. So C, I mean, if it were this, then it could be potentially admissible substantively too. But we're just saying what's a requirement for it to be admissible on its face, that it doesn't.
And so is this basically saying that if it was made under oath and you're using it to impeach, you can make enter it substantively, like to convince the jury of the fact of what you're entering. Whereas if it was under oath, it's just to like show the jury this person's compromised and not telling the truth.
100%. Yeah. If
Okay.
it's not under oath, it can only be used for impeachment purposes. If it's made under oath, it could be used for impeachment purposes, and potentially it could also be brought in substantively. The thought being like you were already under oath, you were subject to cross, like the statement is coming in. But that wasn't what they were asking here. They're asking for admissibility just on its face. The prior inconsistent statements come in for impeachment purposes, and they don't need to be made under oath. They just need to be inconsistent, offered to impeach, and the declarant must now be subject to cross-exam so we can ask them about it. Which of the following is not a requirement for admissibility of habit under Florida rules of evidence? The evidence must be specific and consistent. The habit must have occurred on a sufficient number of occasions. The habit must have been developed within the past year, or the habit must be relevant to the issue at trial. I mean, C makes no sense. Habits, I don't know if I've developed any habits in the past year. I don't know. The evidence must be specific and consistent. The habit must have occurred on a sufficient number of occasions, and the habit must be relevant to issue a trial. Those are the factors for habit evidence. Under the Florida evidence rules, which of the following is not a requirement for admissibility of recorded recollection? So what are the requirements? The witness once had personal knowledge of the matter. The witness now has insufficient recollection to fully testify. The record was made by the witness when it was fresh in their memory. The record was made in the regular course of business. I mean, D comes out of left field. That's a business records thing. But this is very important. These are the recorded recollection. Recorded recollection is exactly this. The witness once had personal knowledge of the matter. The witness now has insufficient recollection to fully testify. And the record was made by the witness when the matter was fresh in their memory. So I'm going to go with D. D is just not important. During a trial for financial fraud, the prosecution calls a witness who is the defendant's accountant. The prosecution intends to question the accountant about financial advice provided to the defendant. The defense objects to testimony on the basis of the privilege. How should the court rule on the objection? The court should sustain the objection based on attorney-client privilege. The court should sustain the objection based on the spousal privilege. The court should overrule the objection because there's no applicable privilege. The court should sustain the objection based on the accountant-client privilege. Yeah, it's actually D. Florida does recognize an accountant-client privilege, right? Florida does recognize an accountant-client privilege, and this seems to be accountant-client. I'm not even gonna say anything. I love my accountant. I love people I love in this world. Accountant's one of them. You gotta love your accountant, or you should get a new one. Under Florida evidence rules, which of the following statements, you should love your tutor too. Under which of the Florida evidence rules, which of the following statements regarding impeachment with criminal conviction is true? The privilege against self-incrimination applies to past convictions and prevents their use for impeachment purposes. Only felony convictions are admissible for impeachment purposes. A witness's credibility is irrelevant when considering the admissibility of past convictions for impeachment. Impeachment with criminal convictions is permissible on cross-examination. I don't think so. Impeachment with criminal convictions is permissible on cross-exam? The privilege against self-incrimination applies to past convictions and prevents their use for impeachment purposes. I don't think so. Only felony convictions are admissible for impeachment purposes. That's not true. A witness's credibility is irrelevant when considering the admissibility. I don't think so at all. So it's got to be D. Impeachment with criminal convictions is permissible on cross-examination. All right, sorry, I don't know why I was thinking. Impeachment with criminal convictions is permissible on cross-exam, right? Unless potentially the criminal conviction is so long ago that it has no bearing on truth today. But the court has discretion for those. It's not over 10 years. It's just like certain score ago. The provided statement explains that Florida follows the view of the federal rules regarding impeachment with criminal convictions. In Florida, as in the federal rules, a conviction for a felony punishable by imprisonment in excess of a year or a misdemeanor involving dishonesty or false statement can be used for impeachment purposes. Perjury being a crime of dishonesty can be raised for impeachment purposes on cross-examination. Under the Florida rules, what is the admissibility of learned treatises and their use in court proceedings? Learned treatises are admissible as substantive evidence to prove the truth of the matter asserted. In Florida, there are no exceptions to the hearsay rule for learned treatises, and they're admissible only for impeachment purposes. Learned treatises are admissible as substantive evidence, but only if recognized as authoritative by the expert of the court. learned treatises are inadmissible in Florida courts and cannot be used for any purposes. So this is the learned treatise, right? So Florida versus federal. Florida does not have a learned treatise exception. We're not going to let learned treatises in Florida, but they can be admissible for the impeachment of an expert witness, right? So B is the best answer. There's no exception for learned treatises. That's true, but they can be used for impeachment of an expert witness. They can be used to attack the credibility of an expert on cross-exam once the expert or court recognizes the writing as authoritative. However, they cannot be used as substantive evidence to prove the truth of matters asserted in them, right? In federal law, they potentially could. Under Florida evidence rules, who has the privilege to claim and protect the confidentiality of a communication between a person and a member of the clergy in their capacity as a spiritual advisor? Only the person who made the communication, only the member of the clergy, the person who made the communication, the guardian or conservator of a person, the personal representative of a deceased person, and the member of the clergy on behalf of the person, or only the personal representative of a deceased person. Yeah, see, right? We all have that duty. During a criminal trial, the prosecution seeks to introduce a police report as evidence of the defendant's involvement in the crime. The defendant objects, arguing that the police report is hearsay. How should the court rule in the objection considering Florida evidence rules? The court should sustain the objection because police reports are generally considered hearsay and not admissible unless they fall within a recognized exception. The court should overrule the objection because police reports are admissible as public records under the Florida evidence rule. Absolutely not. The court should sustain an objection because police reports are admissible as business records under the Florida evidence rules, or the court should overrule the objection because police reports are admissible as recorded recollections under the Florida evidence rule. Yeah, they're not coming in Florida. That's just a general rule. Be very wary to let a police report in Florida. In federal law, maybe, unless there's hearsay on the police report itself, it could be a public record. But in Florida, definitely not. We don't like police reports. In Florida, what is the general rule regarding the admissibility of opinion testimony to prove character? This is supremely important in Florida evidence. Might have to call Taylor Swift up. My good friend Taylor Swift. You all know me and Taylor go way back. We were born in the same year, well, we grew up in the same state and we were born in the same year. Character cannot be proved by opinion testimony in Florida. Opinion testimony is admissible to prove character in Florida. Reputation testimony is the only permissible method of proving character in Florida. And both opinion and reputation testimony are admissible to prove character in Florida. Yeah, we cannot bring in character. Yeah, 1989 was a good year. Super good year. Me and Taylor were born. It was the year that Gorbachev tore down the Berlin Wall. Jim, you're gonna say something? You remember 1989? All right. Under Florida evidence rules, what is the court's discretion regarding judicial notice of a fact and its conclusiveness in both civil and criminal cases? Okay, so this is in Florida. In Florida, the standard for civil and criminal is if the court must take a judicial notice, then they may, but are not required to accept it as conclusive. In federal, it's different if it's civil or criminal. But in Florida, it's always they must take notice because it's like, a notice fact, but they may, but are not required to accept it as conclusive. So the court has discretion to determine whether judicial notice of fact is conclusive, but only in civil cases. The court has discretion to determine whether judicial notice of fact is conclusive in both civil and criminal cases. That's a big takeaway from today, that in Florida, whether it's civil or criminal, the court has discretion whether judicial notice is conclusive. In federal, if it's a civil case, they don't have discretion. But in Florida, civil or criminal, they always have discretion. All right, amazing. So that was pretty solid work for today. There's just one thing I want to do just quickly and then call it an afternoon. But like just in general, you go to these study guides. People say, Andrew, what's the best way to study? I try to like spoon feed it to you all, my course, my tutoring, my cram guides, my workshops, like couldn't make this more spoon fed and if I tried. I mean, I'm actually trying, so maybe I can. But in general, when I studied for this test back in my day, I was doing a big box program, like very quickly into it. I was just like, couldn't do it. The lady started singing to me about real property. The wall started caving in. They started hating on the Jets. And I had to run. I mean, they started loving on the Jets, hating on Dan Marino, and I just had to run. So like, I was like, how am I going to actually pass this test given that there's no resources out there for me. And I came up with the obvious strategy. Go to the Florida study guides and go, starting from the top, go through all the essays that have ever been written, read through them, outline them, make sure you can articulate all the rules of law from all those essays, and then you'll be good to go in the essays. And then the multiple choice questions, like, yeah, just like we put them here, the FEB practice questions, right? Right? These are the questions that you should be practicing from, because these are the ones that, I've done them so many times, I could just get them right without even looking, because I've done them over and over. So I would recommend go over these essays, outline them over and over, and take a look at the questions at the end, right? The multiple choice questions, and just for your own sake, try to do them at the back of these essays, just because like you get to see them in their format and things like that. I'll tell you, and that's why I'm going to assign you, and I have assigned you additional questions. The Florida multiple choice section on the exam is brutal. It's always harder than anyone expects. They'll be like, what's the answer? A is 1 and 2, B is 1, 2, and 3, C is 1, 2, and 4, and then D is like written in Chinese. You can't even fucking read it, right? It's like a very, very difficult test, right? And you'll always walk out of there not feeling good. That's why you gotta feel good on the essays. And if you're taking the MBE, pretty confident in the MBE. Nobody ever walks out of Florida multiple choice like, oh, I crushed that one. The questions come from left field. You don't know what subjects are being tested. It could be business NDs. It could be, wills and trusts. Who knows, right? So it's like not gonna be an easy test. But the tried and true approach is going through these multiple choice questions and seeing, do we know the answer to them? Doesn't this question look really familiar, right? Like after the close of the pleadings, which is correct? D, right? If the plaintiff's proofs submitted in support of the motion are not contradicted and they show no genuine issue of material fact exists, summary judgment will be granted even if defendant's answer deny the plaintiff's complaint. Like that's a question, right? So let's see. A defendant charged with first-degree murder shall be furnished with a list containing names and addresses of all prospective jurors upon court order, upon request and showing of good cause, or under no circumstances. Sean, what's the answer to this question?
B.
Yeah, upon request, right? We get these right from them. So this one, we also do an FBB question, right? Defendant was arrested on February 1st and released 1 month later on March 1st after being charged with a felony. On December 1st of the same year as his arrest, he filed a motion to discharge since no trial or other action had occurred to that point. The defendant held a hearing 3 days after the motion was filed. Okay, they had 5 days to hold the hearing and they did hear it. So now what should happen to the defendant? Discharged, brought to trial within 90 days, or no, D, brought to trial within 10 days, because that's what happens when we have, the hearing. They had 175 days to do it. They they made the motion for speedy trial, expiration of speedy trial date. They held the hearing within 5 days, so now they have 10 days for the motion to discharge. Let's see. I just did this one super quickly, but we'll do it again. Defendant was seen leaving neighbor's yard with neighbor's new $10 garden hose. And the neighbor called the police, who charged defendant with a second-degree misdemeanor of petite theft by issuing a notice to appear in the county courthouse 1 week later. Defendant appeared at the scheduled place and time and asked the judge to appoint a lawyer to represent him. The judge found defendant to be indigent. The judge should appoint him a lawyer, need not appoint him a lawyer if it's 6 months, trick, or the correct answer. Need not appoint defendant a lawyer if the judge states in writing that defendant will not go to jail at all if convicted. That's the standard. You don't need to appoint a defendant a lawyer if the judge states in writing that defendant will not go to jail at all if convicted, right? How about this one? During a depo upon oral examination, a party's counsel may instruct an opponent not to answer a question for which of the following reasons. The question asked for hearsay testimony that would be admissible at trial. The question asked for evidence protected by a privilege. The question asked the opponent for an opinion concerning the ultimate legal issue of the case, or none of the above. Anyone know the answer to this one? Not to answer for which of the following reasons?
B.
Yeah, B, we just did the same question that asked for something protected by a privilege, right? All right, and then, there's not that many questions. There's only 23 on this one, but then you can kind of go through, check out the answers. But I'm just saying, like, it's not rocket science, right? To pass the Florida bar, in my opinion, because they give you the study guides and you just want to like, here's the 2024 study guide. How would I study for this if this was me? I would check it out. I'd be like, all right, let's go to the first essay. Boomity boom. I'd see what's going on here. I'd be like, oh, well, let's not do that one. That one's actually crazy. But like, let's just say it's this one. I'd be like, okay, what's going on here? It looks like there's real property and contracts. These are the questions, the claims, possessory interests, and the merits of the claims. I kind of read it through it and I'd be like, maybe it looks like merger. Maybe it looks like needs to be in writing. Maybe it looks like deed. Maybe it looks like general warranty deed. Ask myself, Andrew, do you know what are the 6 warranties to a general warranty deed? Can anyone humor me? Does anyone know what they are? The 6 warranties to a general warranty deed? 6 covenants? 3 present, 3 future. Does anyone know in the class?
Phasing, no encumbrances, the warranties. Oh, sorry, yeah.
Right, that was good. I'll give you a half credit. Anyone have it solidly down? Trust me, by test day, I need you guys to be robots, right? All right, for the general warranty deed, the 3 present warranties are the right to convey, the right against encumbrances, and the right of season. The future warranties are general warranties, further assurances, and the right of quiet enjoyment. Whatever, I'm not sure that's what they're testing here, but look, I'm like, before I'm even looking at the essay response, I'm like, all right, what are the issues? I don't even know if that was an issue. I'm just doing it quickly, but I'm like, what are the issues? When I see an issue, what rule would it be? And do I actually know the rule? Or do I need to go back to the questionnaires, commit it to memory, XYZ? So you do the issue spotting. If I had all day, if I had Kim Kardashian and we were in a cabin and we had the personal chef and the private trainer and all the amenities, I would have her actually write these essays out every morning. And then we'd go over them in the afternoons. And then in the evening, we'd just, do, call and review, study, whatever it may be. But like, if I had the time, I would write them all out. Without having the time, I would just issue spot them, ask myself, do I know what the rules are, test myself, and then of course go right to the model answers and just start like teasing out the rule of law. Like this was a contract one. So what's an acceptance? Okay, what is consideration? Bargain for exchange of legal benefit or detriment. Okay, nice. What else was on this one? Promissory estoppel. Okay, do I know what the definition is? Like you just want to like go through these, tease out the rules of law, like and just learn from them and then go through the next one. Just same thing, like look through it. Oh, this might be about negligence. It might be about assault and battery. Do I know them? Okay, it's about negligence, duty, breach, causation, damages. Okay, read through it. Like, is there any, dangerous instrumentality? I didn't know that. Florida has a specific cause of action against those who entrust their vehicle to others. Definitely write that one down. A person who entrusts their vehicle to another and then harm is done by the vehicle entrusted is liable to the person harmed under the dangerous instrumentality doctrine. Right? So that's pretty much what you're doing. You're combing through these previous essays to see like what's being tested, how's it being articulated, and are there any rules being mentioned that I didn't know? And let's turn them into things I have memorized. So if you can just kind of do that approach, go through all of the previous study guides. I do it in chronological descending order, go through the essays, issue spot them, compare it to the model answers until you feel comfortable that you can articulate everything in the model answer. Obviously, go through the multiple choice questions until you have all those memorized, and then complete our Q bank from head to toe, and then probably sign up for the boot camp and put yourself to the test that like, okay, let's start doing these practice tests and seeing where I really am. If you can't do the boot camp, then you could just go on here, pick up a year, put 3-hour timer up, do the 3 essays, write them out. And then for the multiple choice, I mean, just keep doing practice multiple choice questions on your own or trying to figure something out. But like, we're getting down to the point where it's like, it's been cool learning this stuff, but now you got to really start testing yourself and be like, do I know it? Do I have it memorized? And can I articulate it? The Florida multiple choice section is super hard for sure. I really hope that you all learned some things today, but like definitely go back, finish those 25, we only did 25 to 50. So finish those. And then there's additional questions that you're assigned, go over them tooth and nail and, just try to review them. Something really crazy that I've realized is I'm actually only teaching 3 more Florida classes this year. I'm teaching business entities, commercial paper, and secure transactions. That's all easy for me, right? It's just money talk, my favorite activity. And then I have Rebecca teaching wills and trusts and ethics, Marion teaching family law, and actually no wait, Marion's teaching wills, Rebecca's teaching trust, Rebecca's teaching ethics, and then Marion and Emily are teaching family law. And then I'll come in for the review session. But you're only going to hear lectures from me from now on from Florida for 3 more sessions for business entities, commercial paper, and secure transactions. So that's how life goes, man. If you were annoyed by me, don't worry. I'm almost done. And the February exam is coming up soon. Want to make sure we're all super sharp. I hope people enjoyed this workshop. It was really fun for me. I'm going to go ahead and stop this recording.